Members, good morning. This is already the 6th meeting of the Bills Committee on Inland Revenue Amendment Bill 2013. We formed a quorum. Please invite the administration to join us.
早晨，早晨。早晨啊，咁多位。
Good morning. We all know the officials, and I will just skip the introduction part. This is the 6th meeting of the Bills Committee on Inland Revenue Amendment Bill 2013. At the 4th meeting, technically, we completed the clause-by-clause scrutiny of the bill. However, there were a few legal issues and issues of principle pending. So I understand that the administration has prepared a paper for us to discuss 3 main issues of principle, and I will give the floor to the administration, the Deputy Secretary, to explain the issues to us. Privacy issues, and also how we can monitor the operation of the agreement, and how the administration consult the stakeholders before signing CDTAs or TIEAs. I give the floor to the Deputy Secretary. Thank you, Chairman. And members, good morning. Well, to recap, after the last meeting, I think Mr. Alan Leung said that we should consult bodies such as the Law Society and other stakeholders to see if they have got further views. And at the last meeting, we submitted the members' views of the Law Society Bar Association and the Hong Kong Chinese, the Association of Chinese Accountants. So at the last meeting, we discussed a few issues, and I think we'll go back to the issues covered at the last meeting. Ms. Sari Lee and Mr. James To, as well as Mr. Yu Shiwing, asked when we're negotiating CDTAs and TIEAs, how do we set out our priorities and strategies, and how can we ensure that stakeholders are involved and can monitor the process? As pointed out in the paper, we have this arrangement. Every year, we discuss with partner organizations. We consult all stakeholders from the business sector, the legal sector, and also tax experts and their professional associations. In light of the views they give us on concerns, we will work out the annual plan. Of course, this is an interactive process because these partners also have their own thinking. After we have an idea of the time frame of our partners, and before we start our negotiations, we will make known to the public through the IRD's website. For instance, we were about to start our negotiations with France and Italy, and the relevant chambers of commerce gave us views which we will certainly consider. Regarding the flow chart, please refer to Annex A of our paper. And this is a gradually evolving process. Now we have two things are happening in parallel, CDTA and TIA. So how do we decide on the priorities? We must have a systematic way of doing things and flowcharts so that stakeholders can be involved and consulted, and we'll also report to them the progress of our negotiations. Well, as I mentioned last time, we've got the Joint Liaison Committee on Taxation, JLCT, where there are many professionals from various sectors, and there's a forum for us to report to them our negotiations. And Ms. Dari Lee raised concerns about cost. Well, the Organization for Economic Cooperation and Development's model text on TIA carries a standard provision on cost, which provides that incidence of costs incurred in providing assistance shall be agreed by the contracting parties. As disclosed at the last meeting, our thinking is if the cost involved is just the ordinary cost incurred in the ordinary course of administering our domestic tax laws, then such costs will be borne by Hong Kong. However, when we are talking about extraordinary costs incurred in obtaining a large bulk of information and conveying these documents to a requesting party, we will charge the requesting party. The details will be negotiated with our contracting partner. And at an earlier meeting, Mr. James To raised an issue about Section 4 of limitation on disclosure. We're going to fine-tune the limitation on disclosure. We have to comply with the foreseeably relevant standard, and all the information required will be related to those after the commencement of the agreement. And if the information sought is before the commencement date, we will be flexible. Mr. James To is concerned about the time period for keeping of information. We have no intention to change our current requirement of 7 years. Mr. To is concerned that perhaps there might be further requests of information arising from the disclosure of information. Now, according to OECD's standard, well, there is an interpretation for foreseeably relevant. The standard is the information required must be necessary and relevant to the operation of the agreement. As set out in the model text, if we just use necessary and relevant, that is not comprehensive enough. So after discussion by OECD and exchange of views by different parties, it is believed that foreseeably relevant is preferred and also feasible standard. And when there is a request for information, we must ensure that the request is relevant to the first request for information. Now, if the request for information has arisen from the information provided upon the first request. If it is not necessary and relevant to the first request, then the ILD will refuse to provide the information. We have this put on record, and we've made it very clear to members here. Now, Mr. Sin Chung Kai has just arrived. Just now, we were talking about our last discussion. Some deputations noted that the safeguards on limitation of disclosure would be listed in the CDTA as well as future tiers, and we have a very stringent review mechanism. The decision by the Commissioner of Inner Revenue is subject to a review by the FS. However, some members asked whether we can make reference to views made by other organizations and deputations. Just to be more assuring, can we have an independent overseeing body or mechanism? And there were suggestions as to mechanisms we could adopt. Well, regarding the operation and complaints against ILD, they have a users committee comprising a dozen or so members from the sectors of legal practitioners, tax practitioners, and academics. The terms of reference would include reviewing regular reports of ILD and also complaints of ILD. So, regarding compliance with safeguards, now because such requests must be kept confidential, so reports on requests of information will be reported to the users committee so that there can be some monitoring. The fourth issue was related to a written submission by the Privacy Commissioner. The submission was tabled at the last meeting. The Commissioner is concerned that in one paragraph of LegCo brief, OECD's model text mentioned that the provided that such use is allowed under the laws of both contracted parties and the competent authority of the supplying party authorizes such use, then the use of information for other purposes can be allowed. The concern is that we have not clearly explained what is meant by non-tax related purposes, and if such arrangements are made, whether there will be any impact on the exemption offered under the relevant ordinance, and also the area on offense, whether there will be any amendment, and whether there is any impact on whether there is any effect. We had a discussion with the legal advisor of the Privacy Commissioner's office, and in our written reply, we have pointed out that first, the so-called non-tax related purpose well, by that we mean that the exchange of information must be first for tax-related purposes. So, under the laws of Hong Kong, there are three relevant pieces of legislation, namely Drug Trafficking Recovery of Proceeds Ordinance, Organized and Serious Crimes Ordinance, and third, United Nations Anti-Terrorism Measures Ordinance.
In these three ordinances, there are provisions stipulating that the commissioner or like any other persons, if the information in their possession are related to such crimes, then they will have the obligation to disclose to the relevant law enforcement authorities. Going forward, in the CDTA document, if the counterparty requests for using the information for non-tax related purposes, we stipulate that these non-tax related purposes would be those which are allowed under the laws of Hong Kong. We also need to ensure that when the IRD is being I think the IRD would need to obtain consent from the law enforcement authorities and the DFJ agreement before they would provide consent to the requesting party. And thirdly, in response to the Privacy Commissioner's concern, we'd like to highlight that under Section 58 of the DVON, what are the crimes which would be exempted? We will stand by Section 58, namely that the offences would need to be offences under the jurisdiction of outside of Hong Kong, and if there is a mutual legal assistance agreement between Hong Kong and that jurisdiction. Under the current bill, we have not proposed to make any amendments in respect of the tier arrangement, and therefore we do not propose to expand the scope of Section 58 of the Protection of Personal Data Ordinance. We will not expand the scope for exemption. Earlier, we've also been in touch with the legal advisor of the Privacy Commissioner. We have clarified the categories which will come under the definition of non-tax purposes, and also in future, in the document, we stipulate that if the requesting party so requires, we will stipulate what are these non-tax related purposes under the laws of Hong Kong, and that consent from our law enforcement authorities would be required, and also they would need to comply with the provisions of our PDPO. And I think and the Privacy Commissioner has not expressed any further concerns, having heard our response. We'll continue to liaise with the Privacy Commissioner on future developments. Perhaps I will stop here. And Mr. Alan Leung said last time mentioned the point about professional legal privilege. I think we already responded to that at the last meeting, but if Mr. Leung has any further views, we'll be happy to respond. Thank you, Ms. Chan. We have Mr. Sin Chung Kai, who would like to speak. You have 10 minutes, Mr. Sin. I'd like to first ask two questions. First of all, the user group you refer to. The law empowers, is it the case that the law empowers the Commissioner to set up such user groups? Because any government organization can set up user groups. So what is the basis of the authority of the user group? Under Section 3 of the Inland Revenue Ordinance, do you have the Inland Revenue Review Committee? How is that related to the user group? The Board of Inland Revenue, what does that board do? Deputy Secretary, regarding the Users Group Committee, is not a statutory body. Its members are appointed by the government annually. Who appoints the members? The members are appointed by the Commissioner. There are 16 members, including tax experts, legal professionals, academics, and representatives from professional bodies. I think the representation is quite extensive. Its terms of reference include the provision of advice on the service and operations of the IRD. The government, namely the IRD, would need to periodically provide details and figures regarding the ILD. Thirdly, it will monitor the effectiveness of the complaint procedure. And thirdly, to provide advice regarding the service of the ILD. Mr. Sin's third question was about another committee. Mr. Sin refers to the Board of Inland Revenue. This is a body formed under the Inland Revenue Ordinance. It is charged with the duty of dealing with procedures and the approval of forms. Under the inland, it is actually formed under the Inland Revenue Ordinance. Well, this committee doesn't monitors your operations. The Board of Inland Revenue does not monitor the work of the ILD. It is mainly responsible for formulating rules and approving forms and procedures. You're now using the user group committee, as a response to our concern. But I think the user group committee will only function insofar as it only provide you feedback about your operations and rules regarding the time limit for the submission of forms and so on. And it does not supervise the Inland Revenue Department's disclosure of information. So first of all, I don't think this user group will be discussing matters relating to disclosure of information. For example, if the ILD receive a request for disclosure of tax information, would it deal with the objections and appeals arising from that? Would there be any, the user group committee, I've been sitting on such committees, similar committees like this one. Normally the committee would be given statistics. It's advised that it has received such a number of complaints every year. It doesn't have the authority to ask questions about details and so on. So can this user group committee really monitor the ILD regarding disclosure? Chairman, I recall that at the last meeting we pointed out that under the IRO we have very stringent and detailed rules regarding how the Commissioner may deal with requests for information and how we can ensure that the taxpayers will be informed and that he may provide for his own information and ask for amendments to ensure that we comply with the necessary safeguards. We emphasize that such information must be kept confidential, and we attach a lot of importance to this. And thirdly, we note that at the last meeting, Mr. Sin and Mr. To made reference to the same point. That is, how can we ensure that the operation and the procedure of the ILD are such that the statutory protection provided for in the law are effectively being implemented. So we believe that if we're talking about the fundamental principle, if we're going to talking about review of the contents of an appeal, we need to deal with that carefully. But now we're now this user group committee, at the moment, it may not be able to deal with many complaints. Of course, the ILD does receive many complaints regarding tax assessments from time to time, but the terms of reference of this committee focus mainly on the operation and the service of ILD. It also monitors the procedures for complaints. So regarding the effectiveness of the procedure and the smoothness of the operation, I think this is an appropriate mechanism, which would enable us to take a major step forward. Of course, in future, when we need to deal with more and more requests for disclosure of information, we can, in the light of our experience, continue to talk to our stakeholders as to how we can provide further safeguards in the procedure. The Users Committee at the moment will read reports and statistics. We have 16 members on the committee representing the different sectors. We have undertaken to report them on the proposal regarding the EOI. This is a very good forum. We will also expand its terms of reference so that we can take a major step forward. Deputy Secretary, do you have anything to supplement regarding how the OECD requires regarding protection? Any country signing CDTA agreement with Hong Kong would provide for protection of confidential information. Normally, they would not disclose cases involving individuals openly. There is a merit in this approach because it can certainly protect the privacy of the person concerned and his rights under the law. I don't think you should confuse what I've said. I've never said that the information should be disclosed to the public. I hope you will seriously look at the other oversight bodies. They all require the information to be kept confidential. For example, cases handled by the ICAC and the SFOC. If I disclose such information, I'll be imprisoned. Mr. Sin's question is that there is no mechanism under the Inland Revenue Ordinance providing for such a statutory body with such powers. But now they are amending the ordinance. The ICAC and the SFC are statutory bodies set up under relevant ordinances. And under those ordinances, there is a clause stipulating that a monitoring body could be set up. But there is no such provision in the Inland Revenue Ordinance, and this is a problem. They are proposing to expand the terms of reference of the user group. So while they amended the bill, and if they think that there is a need for to provide for parlance, they should also do this as well. If it's not provided for under the Inland Revenue Ordinance, they should also take this opportunity to make an amendment to that effect. I've heard Mr. Sin's constructive suggestion. What I'd like to say is how we can monitor the performance of an organization and whether the oversight body should be a statutory body and how it should operate. In the long term, we need to consider this carefully. We need to talk to the trade. Under the present proposal for the tier arrangement, we are now extending the CDTA legal framework to the EOI under tier. All the protections are there. We've noted members' concern. We also believe that we need to enhance our services and enhance the monitoring of the procedure. And we want to expand the terms of reference of the Users Committee. We hope that we can take a constructive step forward. I think if you take this approach, I'm even more worried. Well, this committee, I believe you won't, review the particulars of a particular case to this user group. But then, if you refer a case to this committee and there are no restrictions, and if the members disclose the details, and then it would be create a lot of trouble. So,
Deputy Secretary, well, we will submit reports to the Users Committee so that it can monitor our operation and give suggestions. A lot of data or information can be provided to the Users Committee without compromising the details. For instance, a number of requests received by IRD every year, and we can provide a breakdown of categories of tax, and also requesting countries and whether views or complaints have been received from the subjects concerned, and whether the Commissioner has effectively informed the taxpayers within the 24 or 14 days statutory time limit, and whether we have complied with our performance pledges. Lots of indicators can be made known to the Users Committee for its monitoring. So we are concerned about the the process, and whether the safeguards can be effectively complied with without disclosing the details of each case. I don't think you can do that. Well, one or two commissioners down the road, things will change. And if you do not do something at the institutional level, I don't think you can do anything. Well, we do have a system. Of course, the Users Committee is not a statutory body, but whether it's statutory or not, we do have advisory bodies within the administration, and this is a long-established procedure. Well, an established mechanism, but you've not changed the checks and balance and the arrangements. I don't care about your internal operation, but you are involving other countries, and that's why I want safeguards to be present. You look at bodies recently established, and you can see that the checks and balance offered by these organizations are very good, and yet the IRD is still behind the recent developments. So you should take this opportunity to catch up. I know the government well. If you don't take this opportunity to modernize, you are not going to do it. I know the government well. All right. Any further questions? Other members, do you have questions in relation to the written reply? Our legal advisor, please. Thank you, Chairman. Para 19 of the paper says that the current bill does not seek to amend the IR ordinance for the purpose of allowing tax information exchange to be used for non-tax related purposes. However, in para 22, it is said that the non-tax related users would be listed in the CDTA text. I'd like to know whether the government is planning to act ultra vires. Because if it is not in the, it's not the objective of the bill, why is it that it will be allowed or included in the text? Well, para 19. The bill seeks to provide legal framework for EOI, and more or less we will follow the CDTA's text or the framework set out there. There will be some simple fine-tuning to ensure that the arrangements will be consistent. Regarding the tier legal framework, we have not set out that the information exchange that can be used for non-tax related purposes. This is very clear. However, we mentioned that in OECDs, they do allow the use of such information for non-tax related purposes, provided that such use is allowed under the law of the contracting parties. The Commissioner of IR can allow such non-tax related purposes if they comply with the three pieces of legislation I just set out: drug trafficking, organized and serious crimes ordinance, and anti-terrorism ordinance. If necessary, such information can be provided to the competent authorities. So if we conclude future CDTAs, if the other party seek to have information for non-tax related purposes, well, we will quote these 3 ordinances in the agreement. And if the future contracting party would like to seek information in this regard, the CIR will have to consult the enforcement agencies, including the police. And if legal assistance is required, then the DOJ will also be consulted to see whether it should be done within the framework of mutual legal assistance. So we are only doing what is allowed in our current laws. We are not doing something not within our laws. Para 21 mentioned 3 ordinances: Drug Trafficking Recovery of Proceeds Ordinance, Organized and Serious Crimes Ordinance, and also UN Anti-Terrorism Measures Ordinance. They involve criminal offences. For CAP 525, the ordinance on mutual legal assistance, I'd like to know how they are related. If you have MLA as well as CDTA with a country, and if the tax information should be used for the purpose set out in the 3 ordinances, should the IRD or the DOJ be approached? Of course, we've never encountered such a scenario. For the 3 ordinances, well, they involve criminal offences, and they are very targeted. For instance, it's about money laundering or anti-terrorism. According to our understanding, offences under MLA cover a wider scope. Hong Kong, with treaty partners, has a framework of mutual legal assistance. If in the text of the IRD, these 3 ordinances are listed, and if the other party feels that there are offences related to these ordinances, a request will be made to the IRD, and IRD will seek approval or consult our enforcement agencies, that is the police and also DOJ. Both departments will see whether Section 58 of PDTO for overseas offences there must be law enforcement cooperation between Hong Kong and the contracting party, and that could include MLA before an exchange is allowed. In actual operation, if there is an MLA channel, usually the IRD would suggest that the other party do it through MLA. If the enforcement agency agrees, and if it is within the scope of the 3 ordinances, and if the MLA framework is satisfied, then information can be provided. The overriding principle is there must be law enforcement cooperation between Hong Kong and that contracting party or the requesting party. Any supplement? Whether we talk about CDTA or TIER, we are talking about exchange of tax information. Under our arrangement, tax information can be exchanged with the other party. And if the other party, upon receipt of information, discovers that it is related to serious offences, well, in the past or before that they could do it through MLA. But since the information is in the hand of the contracting party, it will ask IRD for consent for you to use the information for non-tax related purposes. Okay, thank you. Any other questions, please? No, if not, I have a question. Para 9 of the paper. I'm reading the English text. You have printed in bold this sentence. on limitation of disclosure.
OECD standard is concerned, the formulation foreseeable relevant has been adopted to mean necessary and relevant. 咁你呢個關於 necessary 同埋 relevant 呢兩個字嘅解讀係是否喺 OECD 嗰個 explanatory notes 嗰度係有用到？
I'd like to know whether this is used in an explanatory note of OECD's model text. We've provided EOI article section 26 paragraph 5.3 what is meant by foreseeably relevant and why OECD has chosen this formulation foreseeably relevant because it is more comprehensive. So there are two elements. It must be necessary and also relevant. Thank you. All right, any other questions from members? No? Good. Let's take a look at the legislative timetable. The administration has indicated to the Bills Committee that they would like to resume the second reading debate of the bill on the 10th of July 2013. Then the administration has to give notice to the House Committee Chairman by the 18th of June. And this Bills Committee should report to the House Committee on the 21st of June. If members or the administration would like to move CSAs to the bill, then the deadline for giving notice is the 29th of June. Mr. Sin Chung Kai, well, I have other comments. I'd like to state my position. I oppose the decision by the administration to submit such reports or information on EOI to the Users Committee of the IRD. But because the Users Committee should deal with internal taxation matters of Hong Kong residents, whereas for exchange of information, we're talking about very specific cases involving a bunch of people only. So I suggest we have an independent or separate monitoring body. So instead of allowing a users committee, which is supposed to consider the general issues, even if you don't do it, please do not break the rules by asking the users committee to vet such applications. Although I'm not yet decided, but I'm quite inclined to oppose the bill. Well, the proposal is just to respond positively to concerns of members. The relevant reports will be submitted to the Users Committee. It is, in fact, not one of the recommendations of the bill. It is just an administrative proposal in response to members' concerns.
I'm asking for an apple and you give me an orange. I don't think you're answering my question. Okay, anything else? Any further supplement? If members have no other questions or comments, I'd like to declare that the meeting is now adjourned. I've also informed members about the timetable. Mr. Sin, if you have any amendments to move, please do that submit that to the Secretary before June 29th. Thank you very much, and thank you. I also like to thank the administration for coming. Thank you very much.